part yang saya expect, saya cadang macam kita nak tunggu nak tunggu macam Cik Azmi habiskan dan saya nak tengok part mana yang dalam silibus yang dia tak cover tu saya cover lah. Tapi mungkin dah boleh expect juga kan part mana yang yang kita yang saya akan cover lah. Saya harap kita cover part yang dia tak cover, basically cases lah. Cases dan mungkin some introductory part yang saya rasa perlu di cover. Yang the rest macam procedural aspect tu semua Cik Azmi yang cover. Ya. Yeah? Okay. Alright, so kita mulakan ya. So kita ada berapa? 31 boleh lah ya. Kita mulakan. Bismillahirrahmanirrahim. Saya start recording. Oh, kita dah start recording ya. Saya mak kelas tau. Okay. Okay, so saya share kita punya screen ya. Okay, kita screen lah ya. Saya share screen. Okay. This is the goals ya, goal page. Kalau ada nampak lah dia punya notification tu, saya letakkan satu last assignment. Kita ada satu last assignment untuk winding up. So boleh tengok yang dalam ni ya, dalam part assignment tu saya letak kat atas sekali kan, yang assignment untuk bankruptcy 1, bankruptcy 2 dan kita ada bankruptcy 3 yang setting aside tu. Kemudian kita ada satu lagi yang compulsory winding up. Ya, sekejap ya, saya minta order. Amar tengok adik Mar. Okay, so satu yang ni compulsory winding up. Saya nak minta macam this would be group assignment. Compulsory winding up on mapping of the process of flow of the proceeding. Okay, so basically saya nak minta buatkan satu macam basically it will be you have to study the provision, the Companies Act, okay, and then the order 2018. Saya letakkan order 2018 dekat situ. So I would like you to macam prepare macam a chart as to the flow of the whole proceeding, starting from the start of the process. Mungkin ada statutory demand, remember ada statutory demand yang Cik Azmi dah explain kan. So you have to start with the statutory notice of demand dipanggil. So dalam provision tu dia panggil notice of demand. So kemudian dia sama macam bankruptcy notice. So what is the effect? So dia punya tempoh, contohnya masukkan tempoh dia contoh 21 hari kan selepas submission ataupun service of the notice of demand. Okay, and then you can file the petition. Okay, and then lepas file petition tu together with what document? Mungkin affidavit verifying the truth of the proceeding. So yang tu Cik Azmi akan explain malam ni insyaAllah ya. Okay, and then what you need to do after that. So that is macam to serve the document to the company, which is to be wound up. Okay, so then berapa lama tempoh, apa yang nak kena buat, contoh you have to file in the affidavit of service. So you can see that the proceeding for the winding up is similar, more or less similar with the bankruptcy proceeding. So which you have to start, kalau bankruptcy proceeding dia start dengan bankruptcy notice kan. Okay, and then kalau yang company dia start dengan notice of demand. Okay, kemudian dia punya document to start the process in the court is the petition itself. Yeah, so the petition tu it would be attached together with the affidavit. Affidavit verifying the truth of the statement in the petition. Okay, and then what you need to be to do tu apa dia seterus so on so forth sampai the order of the court. Yeah. So basic idea is that you study the provision, both the act and the rules, and you make it in the form of chart. So make it in a group. Yeah. Okay, so I give the deadline 14 August kan lama sangat. Yang ni dua minggu saya. So okay lah kan. Kita punya final exam would be end of the August kan. So the deadline for submission of your marks would be early September. So saya rasa 14 of August would be good for you to prepare your infographic. Okay? Boleh. Any question about the assignment? Tak ada soalan. Okay ya. Boleh? Alright, so that is the assignment, the last assignment. Yeah? Okay. So then kita tengok part yang goal ni juga, yang part compulsory winding up, you can see ada dokumen yang saya tambah jugalah ya. You can see these are the samples that are provided given by Cik Azmi on statutory demand. So kita tak sempat lah semester ni untuk buat, dan biasanya kita buat yang statutory demand tu, tapi semester ni saya rasa mungkin too much assignment would not be good untuk online punya ni. Jadi kita jadikan group assignment yang untuk flow chart tu saja. So then sample for the petition, okay, and then I attach together juga affidavit yang verifying the truth of the petition tu, yang menentu sahkan petition, sama dengan bankruptcy petition, dia ada affidavit kan. Okay, kemudian yang ni ada lecture record by Encik Azmi, okay. And then yang ni slides yang kita tengok hari ni sekejap. Ya, ada sedikit lah macam introduction, ada certain part cases yang saya nak tambah daripada apa yang Encik Azmi bagi. Kemudian saya masukkan juga dekat sini Companies Winding Up Rules 2018. So kalau banyak reference yang dibuat oleh Cik Azmi adalah kepada Winding Up Rules 1972. So dia sama je lah, cuma nombor dia ada berubah sikit lah. Ya, tapi dia punya in term of the content ataupun the process tu is similar. So you don't have to worry about it lah, cuma sebab it has been updated, so we make reference to the 2018 rule. Yeah? Okay. So yang dekat sini ni last assignment punya lah ya. Okay, dan juga saya ada juga share dekat sini slides by an officer in the insolvency department yang Puan Yusnita ni kita panggil masa semester, saya rasa dalam semester lepas. Ya, dia explain tentang apa proses dekat insolvency department tu. So basic idea dia general je lah, is general explanation about the role of the insolvency department. And then mungkin you can, dia punya explanation ni dalam bahasa Melayu. So I think it would be good if you glance through lah the slides prepared by Puan Yusnita. Yeah? Okay, so that is about the materials that I recently uploaded to Goals for your reference for the preparation of your final examination as well. So untuk examination kita memang fokus untuk winding up saja. Ya, sebab kita dah ada bankruptcy, the test before we focus on the bankruptcy. So for this coming final examination kita fokus untuk winding up saja. Ya, so I think it will be macam mungkin dalam senario macam environment of the online teaching and learning. So I think mungkin kita lebih easier to make chunk of it rather than macam the whole of it to be in the final examination. Yeah? Okay, so that is about your assignment. Okay, and then explanation about the materials in goals. Okay, and then the final examination as well. Yeah. Okay, so next kita tengok sikit tentang winding up, compulsory winding up. So this is basically an addition to what has been given by Cik Azmi. Okay, and then saya harap malam ni dia tamatkan lah yang bab proceeding on compulsory winding up. Yeah, so basic idea secara amnya on the part of the procedure tu will be covered by Cik Azmi. Yeah. Okay, so saya tak cover yang kat sini, kita tengok ada 40 slides kan, so kita taklah cover kesemuanya kat sini sebab Cik Azmi, saya harap Cik Azmi akan cover ya. Okay, so this is kita tengok sikit je tentang yang ni, kita besarkan kejap. So any question? Slideshow. Okay, saya sepatutnya habiskan ni dulu ya. Sekejap. Okay, kita start dari awal ya. Okay. Okay, so this is a slide that I prepare for the compulsory winding up of companies. Yeah? So you can read together with the macam with the provision in the Companies Act. Okay, and then the Companies Winding Up Rules 2018. Okay, and then lecture by Encik Azmi helps you to understand the procedure. Yeah, what is it? Okay, so saya tak tengok lah dah apa dia macam apa yang saya rasa macam Encik Azmi dah bagi tu, kita skip je lah ya. Okay, so basic idea is that I think you have learned this from Encik Azmi that the proceeding in the for the compulsory winding up is started by way of petition. So it is similar to the bankruptcy proceeding. Yeah? So this is under section 464, in which it is made by petition. made by any one of person as provided in the section. So ada banyak orang lah, there are many person who may file the petition. So not only the creditor. Kalau dalam bankruptcy proceeding, so is the creditor je, creditor yang generally lah, the creditor will start the proceeding against a debtor in bankruptcy. Okay, however, for the companies compulsory winding up, so there are many person which may start the proceeding. So kita tengok who can file the petition in court. So under subsection 1 to section 464, a company, whether or not it is being wound up voluntarily, so that means in the process of voluntary winding up, the company may still be compulsorily wound up. So maksudnya dalam proses dalam proses voluntary winding up, so the creditors may still file in the court the petition for the company to be wound up. Okay, so that's the situation, basically the starting proceeding under section 464. Okay, so we look at who can file the winding up petition. So as I mentioned to you just now, they are not only, kalau kita compare lah dengan tak boleh gerak yang ni. Okay, kalau kita compare with the bankruptcy proceeding, so it's generally the creditor can start the proceeding against the a debtor in order to make the person bankrupt. Okay, however, for the company, so these are the people ataupun the person who may start the ataupun who may file the petition. So the first one is the company himself. The company himself. So yang ni sama dengan bankruptcy proceeding, in which the debtor may start the proceeding for bankruptcy to make himself bankrupt. Okay, so that is the first one. Okay, and then the most common person who file the winding up proceeding is the creditor. The second one, the creditor, including a contingent or prospective creditor of the company. So contingent tu yang sedang lah, prospective tu macam for example, there is macam mungkin the debt is to be payable mungkin next year. Okay, yang tu prospective. Okay, however, there is a risk that the company mungkin there is imminent risk ataupun it is expected that the company may not be able to pay the debt. So then this creditor may also file the petition against the company. Okay, and then the third one is the contributory, or any person who is the personal representative of a deceased contributory, or the trustee in bankruptcy, or the Director General of Insolvency of the estate of a bankrupt contributory. So the key word here is contributory of the company, may also wind up a company. So remember, contributory of a company is a person who undertake, commonly a member of the company, who undertake to contribute to the company upon winding up of the company. Orang yang liable lah over the liability of the company. So that is the third person. So the fourth one is the liquidator of the company. A liquidator who is under the process of the liquidating a company. So dia boleh juga start a company to be wound up. Okay. And then the fifth one is the minister. Tapi yang ni specified ground sajalah which is specified under paragraph D or L of section 4651. So kita tak tengok yang ni secara detail lah. So basic idea, minister can only file a petition to wind up a company under certain situation. Okay, and then in the case of company which is a licensed institution, macam bank, macam financial company, macam takaful company for example, so the only institution which may file wind up petition is the Central Bank of Malaysia. So yang F ni adalah untuk yang conventional punya. not necessarily so actually. So yang F ni dia untuk banking, bank and financial institution, insurance as well. Yeah. Yang dekat bawah ni kalau yang designated payment system, operator of a designated payment system. So institution which may start the petition is the Central Bank of Malaysia as well. Okay, and then H, the registrar on the ground specified in paragraph 465. Contoh macam pertubuhan pertubuhan yang didaftarkan pun boleh wind up as well by the registrar. Okay, and then in the case of a member institution under Malaysia Deposit Insurance Corporation, yeah, the person ataupun the institution which may wind up the company is the Malaysia Deposit Insurance Corporation. Yeah. Okay, so this talk about who can file the winding up petition. So it concerned with the local standby. Yeah, the person, contohnya kalau a person who has nothing relating to the yang maksudnya not included under this provision, will not have lockers to file the petition, yeah, to wind up a company. Okay, so that is about who can file the wind up petition. Yeah. Okay, so next kita tengok tentang circumstances in which a company may be wound up by card. Okay, so generally a company would be the ground for winding up would be the inability to pay debt. Yeah, so yang ni the most common ground, saya merahkan dekat sini lah. Yeah. So the most common ground for a company to be wound up is the inability to pay its debt. Okay, however, it is not on the ground, yeah, because under section 465 it is, so there are other grounds as well in which a company may be wound up. Yeah, kita tengok sikit yang ni. Yeah. So under paragraph A, the company has by special resolution resolved that the company is to be wound up by the court. So that means the company in its own meeting, so discuss among themselves, then they achieve a special resolution for the company to be wound up. So that is by the company's own initiative. Yeah. Okay, and then B, the company's default in lodging the statutory declaration under subsection 190. So this is the requirement under the law in which the company has to lodge a statutory declaration. So failing to do so, it allows for the starting of the proceeding for winding up of a company. Okay, and then C, the company does not commence business within a year from its incorporation. Yeah, so they stop business ataupun dia suspend its business for a whole year, then it may also subject to a winding up proceeding. Yeah. Okay, and then D, the company has no member. Mungkin mati dah ke semua dia punya members, so then such a company may be able to be wound up as well. Okay, and then E is the common ground for a company to be wound up, that is inability to pay is debt. Yeah. Okay, and then F is the director have acted in the affairs of the company in the director's own interest. So this is also wrong under the law. Yeah? So the directors, when acting for ataupun directing the company, he is under the duty to act in the interest of the members of the company. Yeah? Dan juga the creditors of the company lah, ya, rather than macam kalau dia acted on his own behalf, macam mungkin dia punya own interest, yeah? So that could be a ground for a company to be wound up. Yeah. Okay, that is F. Okay, and then G, when the period, if any, yeah, fixed for the duration of the company by the constitution expire. So there are two situations here. So for example, a company is established ataupun incorporated for the purpose of certain event. Ya, contoh mungkin buat sukan ke, ataupun buat mungkin tahun ni buat certain event like apa yang biasa macam a big event which require incorporation of the company. Mungkin concert ke, ya, mungkin certain celebration for example. So upon that expiration atau bila tempoh tu selesai, so that kind of company may also be wound up by the court. So that could be a ground as well. Okay, and then H, the court is of the opinion that it is just and equitable that the company to be undap. Ya, so yang ni macam orang kata macam open provision which macam any orang boleh bring up to the court to say that such a company is dia macam is on the discretion of the court that such a company is should be undap. Yeah, so yang ni macam open provision lah which allow the court discretion. Okay, that I is the company has held a license under Financial Services Act. Yang ni untuk bank dengan insurance company. Yeah. Dia kata the license has been revoked or surrendered. So in such a situation when the license has been revoked, so it is a ground for the company to be wound up as well. Yeah. Okay, J is for the company which yang I ni untuk company yang ada license tapi the license has been revoked. But J is the company has been incorporated tapi dia dia tak proper punya license, ya. Kita baca ini, the company has carried on a licensed business without being duly licensed. So maksudnya the business tu should be licensed tapi kemudian dia tak license. Ya, dia maksudnya tak dapat license yang sewajarnya. Contohnya bisnes yang perlu, contohnya kontraktor pembinaan contohnya dia kena ada license kan. Okay, however if it is not licensed then it may also, such a company may also be wound up as well. Okay, and then K, the company is being used for unlawful purposes, yeah, or any purpose prejudicial or incompatible with peace, welfare, security, public interest, public order, good order or morality in Malaysia. So in such a situation, yang ni pun can be a ground for the company to be wound up. Yeah? So mungkin macam mungkin kalau a company is deemed to be macam kalau macam media communication for example kan, kalau is deemed to be a threat to the public security, mungkin certain the minister feel that it is a threat, yeah? So macam then it would be macam deemed as unlawful purpose, then it would be a ground for the company to be wound up as well. Yeah? So macam NGOs, contohnya NGOs yang incorporated as a company pun kalau mungkin dia rasa dia punya purpose tu is contrary to the peace of the public, then it can also be a ground to be wound up. Okay? And then yang ni open to the minister lah, the power of the minister under section 590. Okay, so basic idea is that there are many circumstances in which a company may be wound up, not only the inability to pay its debt. However, the most common ground for a company to be wound up is the inability to pay its debt, bila tak boleh bayar hutang. Yeah? So that is the situation. Okay. Okay, so kita tengok dah situation ni why a company may be wound up. Okay, and then kita tengok yang tadi tu the most common ground is the company is unable to pay its debt would be would be a ground for the company to be wound up. So kita tengok apa dia definition for inability to pay its debt. What does that mean? Yeah. Okay, so under subsection 1 to section 466, yeah, a company is deemed to be unable to pay its debt if, yeah, there are three situations here, yeah, A, B and C. So the first one, yang ni yang biasa orang bawa ke mahkamah. Ya, biasa orang bawa ke mahkamah untuk winding up proceeding. Ya. So that is yang macam Cik Azmi cerita tu, yang macam start with the notice of demand. So yang keadaan yang ni sama macam kita punya bankruptcy proceeding. Dalam bankruptcy proceeding tu, dia punya act of bankruptcy tu dia ada banyak kan, daripada A sampai I dalam 9 macam tu kan. 9 ke 8, saya selalu keliru yang tu. Okay. There are many situation in which a person may have committed an act of bankruptcy. Okay, tapi dalam yang company punya, yang tadi circumstances tu 3 situasi. Okay, tapi untuk yang inability to pay its debt tu ada 3 situation. So yang pertama ni adalah yang notice of demand yang Cik Azmi explain. Yeah? So that is one situation in which a company may be deemed to be unable to pay its debt. So how is it? Yeah? That is the company is indebted. Yeah, maksudnya dia ada hutang lah in a sum exceeding the amount. Yeah? Cik Azmi explain kan amount dia 10,000. Yeah? Tapi sekarang masa COVID situation ni, the amount has been increased up to 50,000. Yeah, remember that? Okay, so yang tu 50,000 tu dia macam open lagi, dia macam tak ada tempoh period lah, ya, tempoh period dalam order tu, ya. So, okay, the company is indebted in a sum exceeding the amount as may be prescribed by the minister. So, yang ni dia is the power of the minister to prescribe how much is it. Yeah? So, dalam Companies Act is general. Yeah? Okay, then and a company and a creditor by assignment or otherwise, maksudnya creditor lah, has served a notice of demand. Yeah? Yang ni yang dikatakan sebagai statutory notice tu, ya, ataupun statutory demand. So statutory tu datang daripada perkataan ni lah, 4661 ni. Okay, so maksudnya the creditor has served a notice of demand by himself ataupun his agent tu can be a lawyer lah, ya, requiring the company to pay the sum due. Yeah, so what the notice is to do is to ask for the company to pay the debt. Yeah. So how is it? Is by leaving the notice at the registered office of the company, and the company has for 21 days after the service of the demand neglected to pay the sum or to secure or compound for it to the satisfaction of the creditor. So ayat ni sama dengan yang Bankruptcy Insolvency Act. Yeah? Okay, so basic idea, if the company has been served the notice of demand by the creditor, okay, and then after 21 days, the company has yet to pay the sum, ataupun dia macam tak undertake lah, tak secure or compound for it tu, macam undertake to pay, it can be made by way of undertaking, macam writing a letter to undertake to pay. So yang tu pun a kind of macam to secure for the payment, ataupun macam letakkan satu security ke, so it's a kind of macam promise to pay. Yeah, okay, so in such a situation, bila tamat tempoh 21 days tu, then the company is deemed to be unable to pay, is that. Okay, so the situation here is similar to the bankruptcy proceeding. Remember, untuk bankruptcy notice berapa hari lepas kita serah bankruptcy notice kepada debtor, so how many days that the person is considered as committed an act of bankruptcy? Berapa hari, remember? 7 hari. Okay. Berapa?
7 days.
7 days, that's right. Okay, 7 days. So on the 8 days tu, lepas service of the bankruptcy notice tu, then they deemed to be has committed an act of bankruptcy, kan, kalau bankruptcy. Okay, tapi yang dekat company, dia kata dia punya presumption tu, dia andaian, presumption is the company is unable to pay, is that. Yeah, so bila dia gagal untuk bayar. Yeah, okay, so that is the first situation. Yeah. So bila lepas 21 hari dia tak bayar, so then petition may be filed against the company. Okay, so that is the situation. Okay, this is the first situation. The second situation is that execution or other process issued under judgment. So that means there is a judgment obtained against the company. Okay, and then execution has been made for the judgment. So that is macam execution of judgment can be macam ada banyak lah proceeding, macam writ of sale and seizure, kan. What else? The garnishee proceeding, boleh juga against a company, mungkin attachment of property, of the company. So dia ada banyak proses lah untuk execution of the judgment. Okay, however, upon execution of the judgment, if macam yang selalu yang buat adalah bailiff lah ataupun peguam lah, kan, pergi company tu, contohlah macam dia buat attachment of attachment of the properties company, attachment of the property of the company. Okay, so in such a situation, mungkin bailiff pergi, lepas tu dekat company tu dah tak ada harta yang nak attach tu. So in such a situation, the company would be deemed to be unable to pay, is that. So that is the second scenario in which the petition may be filed against the company. Okay, so that is the second situation. So you can see here, untuk A kat sini, tak perlu ada judgment for you to serve a notice of demand. Sebab dalam provision ni, it does not require judgment to be obtained against the company before a notice of demand may be served. Ya, tapi kalau dalam bankruptcy kita perlukan judgement. Okay, so yang ni yang banyak orang keliru jugalah. Ya, so tak semestinya ada judgement. Ya, yang second situation yang ni yang perlu ada judgement. Okay, then upon execution of the judgement, kalau tak boleh selesai, then a petition of winding up may be proceeded against the company without the needs of serving the notice of demand against the company. Okay. Okay, and then boleh ni? Okay, the third one, it is proved to the satisfaction of the court that the company is unable to pay its debt.
Ada tengah kelas.
Saya punya line not good. Yeah, so can you hear me now?
Yes, madam. I can hear you.
Yes.
Aha, alright. So line saya yang mati, yang putus tadi. Yeah. Okay. So we continue. Yeah. Kita share yang tadi lah ya. So masih sharing ke tak? Okay. So we continue with this. Yeah. So any questions so far? Tak ada soalan. Okay ya. Okay, so just now we talked about the inability to pay is debt. So how does the law presume that a company is unable to pay its debt? Yeah. So kita dah cover yang first and second. So the third one is that it's about macam the court will have to consider the evidence put forward to the court. Yeah. So this is under C. It says it is proved to the satisfaction of the court that the company is unable to pay its debt. Okay, and in determining whether a company is unable to pay its debt, the court shall take into account the contingent and prospective liabilities of the company. Okay, so this is the situation in which notice of demand has not been served to the company. Okay, and then there is no judgment ataupun there is no execution of judgment has taken place. So in such a situation, the law still allow for a winding up petition to be filed against the company. Okay, and then dalam petition tu, dalam affidavit tu, the creditor ataupun the anyone who filed the petition has to proof that is macam to put up the evidence in order to show that the company is unable to pay its debt. Yang ni open sebenarnya. So cuma it's rare actually for the creditors to to take this dan lawyers juga sebenarnya avoid this kind of situation. Ya, sebab it's quite difficult actually to prove debt, especially yang macam debt which is macam can be subject to dispute. Yeah? So kalau debt tu, the debt is straightforward, that is able to be proven by way of macam quite macam not disputed evidence. So in such a situation, the court may accept maksudnya allow the petition and give the winding up order. However, the law still allow for this to take place. Yeah. This is macam saya nampak macam open situation in which a company may be wound up when it is unable to pay its debt. Yeah. Okay. However, selalu orang akan ambil yang A ni dululah. Yeah, that is to serve the notice of demand. Maksudnya kita dah it will be macam easier to, because when you have serve a notice of demand, okay, and then you get the company to macam give notice to the company to pay the debt. So after certain time period, that is the 21 days, once if the company has not paid, only then you file the petition. So that is macam orang kata straightforward lah in order to prove ataupun to presume that the company is unable to pay is debt. Okay. So these are the three situations under the law which allow for the presumption of the company to be unable to pay is debt. Yeah? Yang ni presumption. Yeah? Untuk yang proof yang circumstances E tadi, yeah? The circumstance of inability to pay is debt. Yeah? Okay, can you see the relation between section 4.6 yang tadi tu, yang 4.6 the circumstances just now 465 yang kat sini E tu, dia punya definition of unable to pay his debt tu is under section 4.6.1. Yeah? Okay. Alright. So we move. Boleh? Yeah? Okay, so the notice of demand under paragraph A just now is 21 days. Yeah? They 21 days. Okay, however, the temporary measure has been taken by the CCM through the minister lah, ya. Dia punya exercise the order tu, the person who has the power to declare the order is the minister. Yeah. So the temporary winding up protection, so that is to protect the company from winding up order, is the duration for the statutory notice of demand has been extended to 6 months. Yeah, okay. So for example, lawyers when they issue a notice of demand tu, dia kena letak tempoh dia tu is 6 months. Yeah, cannot be 21 days due to the order here. Yeah. So this allows company to have temporary respite from one form of winding up. So maksudnya dalam tempoh macam difficult situation nowadays due to COVID situation, there are so many companies who are under macam financial difficulties. So this is a way for the company to mungkin to adjust lah for 6 months before they find measures in order to pay debts. Yeah. Okay, you can find the order in here, ya, Companies Exemption number 2 order 2020. Ya, baru lagi bulan 4 ya. Bulan 4 dan 23 hari bulan kata saya boleh tengok dalam ni lah, ya. It has been attached in this website, ya, malaysianlawyers.com. Ya. Okay, so untuk temporary measures 6 months tu has been 21 days tu has been made 6 months, ya. Okay. So the threshold amount has also been increased up to 50,000. Yeah, sekarang is the 10,000. Yeah, beginning from 31st January 2017. Okay, now it is 50,000 beginning from the 23rd April 2020. Yeah, so boleh tengok dia punya dokumen dekat sini lah. Yeah. Okay, so that is the threshold amount. Yang ni Cik Azmi explain lah dah. Yeah. Okay. Okay, so now kita tengok the test of insolvency. So yang daripada perkataan inability to pay is debt just now. Yeah. So how does the court interpret the meaning of inability to pay is debt? Yeah. Okay, so kita goes back to the ground of the winding up application just now. Yeah, inability to pay is debt is the most common ground relied upon in the proceeding. Yeah, so prima facie itu maksudnya based on the basic evidence forward in the court. A creditor who is not paid has a right to file an application for winding up, whatever his other motive may be. Yeah, so basically, a creditor whose the company is indebted to, when the company is unable to pay ataupun tak bayar hutang dia pada masa dia when it is due, so the creditor may start the application for winding up. Yeah. So how to establish this ground and what are the tests of insolvency? So the court has its own macam means lah in order to determine whether the company is unable to pay its debt. Yeah? So the applicant must prove to the satisfaction of the court that the company is unable to pay its debt. Yeah? Cara dia yang tadi itulah A atau B or C. Yeah? So the court when dia tengok it's a presumption. Remember, it is a presumption. So dia bukan konklusif. Ya, dalam 4661 tu tadi dia kata it is a presumption that the company is unable to pay its debt. Contoh bila kita hantar NOD, notice of demand, lepas 21 hari dia tak bayar. So it raise a presumption that the company is unable to pay its debt. So dia bukan conclusive evidence that the company is unable to pay its debt. Yeah? So mahkamah bila tengok, mahkamah akan apply this test. Yeah, the test is the test of insolvency dipanggil. Yeah? So this has been macam helped in the case of Great Eastern Hotel Private Limited. Yeah? Dalam macam contoh on the part of the accountant bila dia tengok sama ada the company is in good condition, dia akan tengok yang dekat sini balance sheet insolvency dipanggil, balance sheet. So that is the total liabilities ni exceed over total asset. Kalau dia macam insolvent, so maksudnya the total liabilities exceed the total asset. Dia punya hutang tu lebih daripada kemampuan dia lah. So saya rasa yang ni dah cover sikit kot dalam companies, your law of company kan. Okay, however, dalam keadaan for a company to be wound up, the court will see this test rather than balance sheet insolvency ni. Dia tak tengok sangat sama ada the company punya asset tu lebih ke ataupun dia punya liability lebih ke, dia tak tengok sangat yang tu, tapi the court prefer to apply this test, that is cash flow test. So that is the inability to pay debt as it falls due. So when the company fail to pay its debt when it is due, so maksudnya bila macam execution of the judgment just now, okay, and then the asset which is attached, for example yang contoh kita tadi attachment of property as a way to execute the judgment tu. Okay, so when upon execution the property is not found in the company. So in such a situation the company is considered as unable to pay its debt. So when it is fall due, so maksudnya bila kena bayar tu kena bayar lah. So kalau dia tak bayar tu maksudnya the company is deemed to be unable to pay its debt. So the court says here of the two, antara dua ni, cash flow test ataupun balance sheet insolvency ni. So of the two, the more commonly invoked is that of a commercial insolvency. So the court will apply this test in order to know whether the company is insolvent or not. So an excess of current liabilities of a current asset did not necessarily mean the company was insolvent. So maksudnya mungkin ada aset dia yang mungkin tahun depan naik harga contohnya, ataupun dia punya share dia mungkin naik harga turun contohnya. So that will affect dia punya orang kata dia punya condition of the company's health. Okay, so this is the test which the court will apply in order to consider ataupun to rule whether the company is insolvent or not. Okay, kita tengok satu case yang mana mahkamah is a recent case 2016, mahkamah affirm lah the situation. Ya? Ada soalan ke?
Doktor saya nak tanya. Okay, the
Husna,
test
ya?
of the test of insolvency ni maksudnya kalau pakai cash flow test, kau akan tengok company tu insolvent bila dia tak mampu untuk bayar debt dia bila sepatutnya dia bayar. Macam tu.
Bila dia tak bayar lah, contohnya dia kena bayar mungkin 4 hari bulan tapi dia tak bayar. So in such a situation, mahkamah akan consider dia sebagai insolvent.
Oh, kiranya doktor kalau macam contoh yang yang 4661 tu yang dia kata company tak mampu tak bayar bila dah diserahkan notice of demand, and then bila creditor buat petition ke court akan tengok dia tak bayar, so itu dah memenuhi cash flow test.
Dan selalunya dia akan jadi isu bila dekat situation yang C kat sini. So yang dekat C ni bila dia dah deem one way, the company tu boleh oppose the notice of demand tu dan tunjukkan dia able to pay his debt. So, kat situ mahkamah akan tengok sama ada the company is solvent or not. Dan juga ataupun C kat sini. Ya. Dekat C that the company is unable to pay his debt, maksudnya notice of demand has not been served to the company, but the petition can still be filed. So in such a situation, the court one test untuk consider is whether the company is solvent or not.
Faham.
So kalau yang dekat A ni kat sini sebenarnya company tu masih boleh oppose. Nanti kita tengok how did the company tu nak macam orang kata nak oppose the notice of demand tu. Sama macam keadaan contoh bankruptcy notice kan. Bankruptcy notice bila kita serahkan kepada debtor masih boleh oppose bankruptcy notice tu. Okay, dan notice of demand pun sama juga untuk yang company masih boleh oppose notice of demand untuk prove this raise presumption that the company is unable to pay its debt, tapi the company masih boleh tunjukkan, contohnya masih boleh oppose the notice of demand by showing that they are actually able to pay its debt, so winding up order should not be made against them. Okay, dekat situ mahkamah akan apply the test. Okay.
Okay, faham.
Okay, thank you Husna. Ya, kita sambung yang test of insolvency. So maksudnya dalam macam interpreting whether a company is insolvent or not, the court will apply the test, cash flow test. Yeah, that is when the company is unable to pay its debt, then the company is considered as insolvent. Yeah. Nanti kita tengok how could the company who receive NOD tu tadi oppose the NOD, ya. Kita tengok yang case WWTAI Finance Limited, ya. Yang ni explanation sajalah ya as to macam dia macam affirm the case before that, ya. That is the court will apply the commercial insolvency test in order to to consider whether the company is solvent or not. Yeah. Yang ni explanation lah saja ya. So in respect of the first yang commercial insolvency, it is in any event now settled law that the issue on the inability to pay debt is to be considered in commercial context, which is the neglect. So maksudnya bila dia tak membayar, macam abaikan untuk bayar lah. So mungkin dia ada harta tapi mungkin dia ada duit tapi dia tak bayar. So yang tu pengabaian tu saja. So perkataan insolvent tu adalah ketidakmampuan untuk tak bayar kan. Tapi kat situ mahkamah tak ambil literally. Mahkamah ambil neglect to pay tu amounts to insolvency. Dia panggil neglect to pay current demands, regardless of whether the debtor is in possession of asset, if realized would permit it to discharge its liabilities. So the test of commercial insolvency simply means that the respondent company is not able to meet current debt when they fall due. It is cash flow solvency that matters, not balance sheet solvency. So this is why it has been said that the company could be both insolvent but wealthy at the same time. Yang ni saya kecilkan ni sebab macam nak highlight dia punya main keywords lah ya. Yang ni cases yang the court referred to, ya. So yang saya kecilkan ni, ya. So kemudian mungkin kalau if you are interested to look at the case, then you can read further, ya, yang citation sekali lah. So the court also said it is wholly insufficient that the asset might be realizable at some future date after the debt have become due and payable. Yeah. So maksudnya even though the company defended that the contoh tentang perkataan inability to pay its debt tu, so it is not material whether the company have asset to be realized at later times. Yeah. For the company to show that it is solvent. Yeah. Okay, so this is explanation as to the test of insolvency just now. Yeah. Okay, yang ni citation saya ambil ni masa dia masih unreported. I'm not sure whether it is reported for the time being. Mungkin boleh semak kemudian lah. Yeah. Okay, so as I said just now, yeah, the NOD tu dia punya service of notice of demand after the expiry of the date, okay, and then execution of judgment tu which has no return. Yang ni sama macam bankruptcy proceeding juga kan. Okay, so it is a presumption of inability to pay debt. So it is a rebuttable presumption. So in which the company tu boleh rebut the presumption. Yeah. So now the onus shift to the company to rebut the presumption by proving on a balance of probabilities. Yang ni the burden of proof lah, yeah, on evidence. Yeah. So dia kata there is a bona fide dispute, yeah, on the sum claim in the statutory demand. Yeah, substantial and reasonable ground. So not a mere denial. So for example, if yang ni selalunya macam situation macam bila ada notice of demand kat sini, okay, then the company tu rebut ataupun dia oppose that the sum claim tu is the amount actually inducted to the company. Yeah. So if there is a dispute, so then the company can show that in order to oppose the statutory demand which has been served against the company. Yeah. Okay, another situation that the company can rebut the presumption is by showing that the company is solvent and is able to pay its debt. Yeah. So in such a situation, kat sini macam mungkin on the part of the defendant lawyers, macam bukan defendant kat sini, macam company which is respondent lah kan, the lawyers for the respondent company tu, so dia boleh fikirkan macam mana nak rebut the notice of demand tu by for the two situation here. Yeah? That is dia sama ada dia ada bona fide dispute against the sum ataupun dia boleh tunjukkan yang the company is actually solvent and it's actually able to pay its debt. Yeah? Okay, so yang ni saya rasa tak perlu saya ni sebab Cik Azmi ada dah cerita kan sebelum ni tentang yang ni detail about statutory demand itself. Cik Azmi dah bagi sampel hari tu kan what is the statutory demand. So basically macam dia minta suruh bayar hutang lah, ya. Yeah? Okay, so ada sikit lah tentang cases lah kat sini kita fokus, ya. Yeah? The debt for the statutory demand tu must be a specified debt. Yeah? So the amount or existence of it cannot be seriously questioned. Yeah? So for example, kalau macam the debt tu is a debt which can be proven by way of documents selalunya. So kalau contohnya macam the debt is tapi selalu company dia proven ataupun macam dia ada documents to prove kan, contoh macam ada agreement apa. Contoh kalau macam benda-benda yang macam damages, for example compensation apa semua, it is not a specified debt which the court has to quantify kan. So based on the proof. Okay, so for a creditor to issue a statutory demand, the lawyers has to ensure that the debt is specified. Ni kita tahu jumlah dia berapa. So kalau jumlah dia tak tahu berapa, contohnya kena kira mungkin damages ke personal injury, yang tu cannot be started by way of statutory demand. Yeah? Okay, and then the second one, it must be liquidated sum. Yes, yang firstly more on the amount tu is fixed and undisputed amount. Okay, yang second ni is must be liquidated. So maksudnya tak perlu further evidence in order to quantify the amount. Yeah, liquidated. Okay, and then the third one, the debt must be presently due. Yeah, maksudnya bukan to be paid next year contohnya. So it must the debt must be due when the statutory demand is issued by the creditor. Ya, yang tu sikitlah cases yang saya tambah untuk yang part of statutory demand explained by Encik Azmi, ya. Tentang cara apa semua tu Encik Azmi dah explain, ya. Okay. Another case, baru lagi case 2019, Likas Bay Precinct Sdn Bhd. So in this case, the court decided that a statutory demand which is issued on decision ataupun award made by a tribunal can be allow for the issuance of the statutory demand. Yeah, sebab before this, the situation ataupun the position of the law before this is that if you receive an award from tribunal, yeah, under Arbitration Act 1952, so you have to record the award in the court. Dia panggil kita record award tu, kita kena bawa ke mahkamah, kita minta mahkamah record sebagai court judgement. Yeah, so dia ada proses lah untuk buat tu. Tapi dalam kes yang sebelum ni, yang Likas Bay Precinct Sdn Bhd tu, mahkamah kata tak perlu. Ya, sebab there has been a change under the law. Bila ada new Arbitration Act tu, dia has undergone changes. So it does not require for the decision made by the tribunal to be recorded in the court before it can be enforced. So yang ni cuma macam the case shows that if you have a decision given by a tribunal, so you can issue a statutory demand for winding up of a company. Yeah. Okay, that is Likas Bay Precinct Sdn Bhd. Alright. Boleh? Yes. So commonly is that orang akan dapatkan judgement dulu, court judgement dulu sebelum keluarkan statutory demand. Tapi in fact under the law it's not necessary unless kalau the debt tu is disputed. Ya, ada serious dispute ataupun the debt is not liquidated. Ya. Okay, that is decision which explain that if you have adjudication decision by tribunal which is not court, so then you can proceed with winding up by way of statutory demand as well. Okay, yang ni saya tak cover, Cik Azmi dah cover. Service tu must be given to the company's registered office. Ada case lah, case kat sini lah yang kita tambah adalah service is good even if the company has actually moved without informing the ROC. So maksudnya before you start the winding up proceeding tu, you have to it's macam best practice lah, bukanlah have to, tapi it's a best practice for you to macam make a search kan. Cik Azmi explain kena buat search dulu dekat ROC dan search juga dekat dekat satu lagi nama saya lupa, yang nak tunjukkan dia punya health of the company tu. Saya lupa, Cik Azmi ada explain dua perkara kan, you make a search. So in such a situation, kalau contohnya the company has actually moved, mungkin dia register tempat lain, tapi bila dia pindah, dia tak bagi tahu, dia tak record dia punya address dekat ROC, so the service is still good. Yeah, even though the company has actually when for example you have served the notice of demand to the address, registered address of the company, then the company has actually moved, then it is a good service. Yeah? So this is stated in the case of Wang Wah Construction, Ying Fung Department Sdn Bhd. Yeah. Okay. Kalau katakan the service of the statutory demand, case yang Simon Development Sdn Bhd ni, the service of the statutory demand was made at the company's place of business. So maksudnya kedai dia tempat lain, tapi dia punya register office tu tempat lain dekat ROC. So yang tu pun tak ada masalah, is not fatal to the efficacy of the SD. Yeah. However, it is a best practice actually untuk contoh macam Cik Azmi explain kan, bila nak serve, contohnya dia punya place of business tu tempat lain, dia punya registered office tempat lain. So you serve two addresses. So it's better to take macam safe side orang kata, so that because the important thing is that the notice reach the company. and the company tahu yang dia dia minta hutang tu dan dia kena bayar, kalau tidak winding up process will be taken against them. So the notice tu is important. Yeah, so that's why I think on the part of the lawyers it is important to make sure, ataupun kalau kena buat 3 servis 3 tempat pun tak apa. So you do that in order to to ensure that the notice has actually been received by the company. Okay. So yang ni tambah case sikit lah ya. Okay. So implication, apa implication dia bila you have served the NOD to the company tapi company tu tak bayarkan selepas tarikh tu. So the presumption, it raise a presumption that the company is unable to pay is that. So yang kat sini je. Okay, dia punya implication is that the company shall be deemed to be unable to pay its debt within 21 days after service, ataupun kalau dalam tempoh yang 6 months ni adalah 6 months lah ya. Okay, then bila ada presumption, dah belajar evidence ke? Kan bila ada presumption raised against one person, okay, and then the burden is on another person tu to show that it is able to pay, is that itulah keadaannya. So if you are acting on behalf of the defendant, respondent company yang kena bayar hutang tu tadi, so then dua perkara yang boleh consider, kita boleh semak record company itulah, sama ada the debt is disputed ataupun the the company is actually able to pay its debt. So then the court has a discretion to consider the situation. Okay, so yang ni lah, yang ni case yang discuss, showing you can show the company tu sendiri can show that it had reasonable doubt for a cause for neglecting to pay the sum demanded. You have to show to the court why after receipt of the notice of demand you do not pay the demand. Is there any reasonable cause for it? Sebab tu yang kadang orang kata dia tak terima lah NOD letak tempat hantar tempat lain lah apa semua. So that is a way for the lawyers actually to defend the company as well lah. Okay, second one, proving that it is in fact able to pay, is that this is another way for you to avoid the winding up order. So tadi saya kata ada cara kan untuk the company to oppose the company's to oppose the NOD. Apa yang company tu boleh buat upon receipt of the NOD. So the company may apply ataupun may file an application for an injunction. Mungkin dah come across kot sebelum ni dalam mana-mana subjek about Fortuna injunction. Mungkin dalam equity ke macam tu. Saya rasa equity, civil procedure pun ada. So how do you oppose? That is by filing the application for the injunction. Injunction tu kita namakan, dinamakan sebagai Fortuna injunction, based on the name of a case lah yang started this. Fortuna injunction is a specific injunction ordered by the court. Court yang the jurisdiction is the High Court to restrain or halt creditor. So maksudnya they stop the creditor from filing the winding up petition after service of the notice. If the company successfully obtain the Fortuna injunction, the creditor is not able to initiate the winding up proceeding against the company. So there must exist reasonable ground for a company to apply for the Fortuna injunction. So what is it? Apa situation tu yang dua tadilah. So that is selain yang tadi dia able to pay his debt tu, dia boleh juga this is dalam kes yang ni, Fortuna Holding Private Limited and Deputy Federal Commissioner of Taxation has been affirmed to be applicable in Malaysia, affirmed ataupun accepted to be applicable in Malaysia. Kita tak tengok detail sangat, kita cuma tengok secara am saja. So kalau nak oppose macam mana so kalau macam necessary to go in detail, boleh tengok cases yang lain lah. So there are two situations in which a company can be granted mahkamah before it grants a Fortuna injunction. Kena tengok two situation. First, where the winding up petition, if presented, has no chance or success to or is bound to fail. no chance of the order to be given. Okay, and then second ground, the creditor is intending to present a winding up petition on a disputed claim. Yeah, the claim is disputed, maksudnya the debt is disputed, which will produce irreparable damage to the company rather than by a suitable alternative procedure. Yeah, so the filing of the winding up petition actually will affect the reputation of a company. Dia punya saham semua akan affect, orang ada any other macam prospective business would not want to proceed any negotiation, for example, with the company. So they affect reputation in a business. Okay, so if this is if for example macam claim which is disputed tu, dia sepatutnya bawa case melalui macam civil suit, ya, bukan winding up petition, ya, tapi dia bawa melalui winding up petition, so it should not be done by the creditors. Ya, so kalau claim tu is disputed, the creditor has to start a civil suit rather than winding up proceeding. Ya, so yang tu mechanism lah to be chosen by the creditor tu must be orang kata tactical as well. Dia tak boleh kalau macam orang tak bayar hutang je terus start winding up petition, ya, sebab winding up petition dia punya implication tu is very very high to the company. Ya, so these are the two situations in which the court may grant a forcible injunction against the company. Ya, against the creditor, bukan the company. Yeah, so creditor dah tak boleh filekan petition if the court give the injunction. Okay, kalau secara amnya lah kita tak tengok kes yang lebih detail ya. Malaysian court have consistently held that a fortunate injunction will be granted when the notice is based on a clearly disputed debt. Yeah. So mungkin issue of damages of a contract, yeah, damages of a breach of a contract. Yeah. So in which mungkin one party rasa is a breach of contract, another party kata is not a breach of contract. Yeah. So yang tu issue yang dispute lah. So in such a situation when there is a dispute over the debt, so injunction would be given. Yeah.
Doktor.
Okay. Yeah.
Kalau company dia bawa dia rebut presumption by proving yang dia able to pay its debt, court takkan bagi dia fortunate injunction.
Okay, so kalau amnya sebab dia unable, yang macam tu bila dia mungkin the presumption is raised kat situ, saya tak nampak pula bila dia mungkin dia kata dia neglect lah, ya. Neglect, saya rasa dia kena tunjukkan juga yang dia juga adalah macam ada situation yang lain lah yang menunjukkan dia winding up order must be taken against them. Dalam keadaan fortunate injunction adalah bila biasanya mahkamah tunjuk bila company tu tunjukkan bahawa dia dispute the debt. Tapi bila dia kata unable to pay his debt tu, situation is another ground in which the company can present to the court. Cuma kes yang untuk jawab soalan tu saya rasa kena ada kes ditunjukkan sama ada mahkamah terima tak bila dia unable to pay his debt tu. Yeah, if based on what the case that we have for the time being, sekarang lah saya rasa mungkin perlu study yang lebih tengok balik case sama ada adakah based on the neglect to pay his debt kat situ boleh tak mahkamah keluarkan fortunate injunction. I think I have to look at cases as well. So basic idea adalah dia tengok kalau debt tu is disputed baru dia keluarkan fortunate injunction. Okay.
Okay, faham.
Saya rasa saya kena tengok case in order to say yes, kalau dia unable to pay his debt, bila dia raise presumption tadi kan, dan raise presumption that the company is unable to pay his debt, okay, and then if the debt is not disputed, the court would not give kalau berdasarkan apa yang kita ada sekarang lah, ya, so the court would not give the fortunate injunction. Yeah, because it's a mere neglect too should not be upheld by the court. Yeah. So to support by case tu saya tak boleh sekarang. Ya. Based on macam saya gunakan based on case yang ada sekarang. Okay. So basic idea is that the court will see whether the debt is disputed. If the debt is not disputed, fortunate injunction will not be granted. Okay. So maksudnya macam the debt tu is unable to be disputed by the company. So then fortunate injunction will not be given by the court. Okay, and then the winding up proceeding may be taken against the company by the creditor. Okay.
Thank you.
You're welcome. Okay, so I think on the part of the company yang receive NOD tu, in a way cara dia adalah to negotiate lah with the creditors tu. Mungkin dia lambat bayar ke kan, daripada neglect. Neglect tu macam mungkin dia keep silent, tak nak bayar, memang refuse to pay for example. Dan sebenarnya dia tak ada dispute against the debt, dia acknowledge that the debt is there. Kan? So in such a situation dia perlu ada cara lain lah, bukan guna fortunate injunction. Ya. Yeah? So unless kalau dia ada dia dispute the debt, then dia guna fortunate injunction to stop winding up proceeding. Yeah? Okay. Okay. Ilham dengan abang? Okay. Okay, so what is the okay, yang ni boleh kata ulangan jugalah ya. Failure to meet a statutory demand would not raise a presumption of insolvency if the debt is genuinely disputed or the company has a bona fide cross claim or substance against the creditor. So apa dia maksud disputed debt ni lah ya. So one-year application is not an appropriate means of enforcing a disputed debt. It must not be used to bring improper pressure to bear on a company. The proper course is to have the matter adjudicated upon in an action for debt, obtain a judgment and then make a winding up application. Okay, so lawyers bila dia nak proceed action against a company, dia kena consider benda ni lah. Kalau the debt is disputed, then you should not use winding up proceeding. Yeah? So dia kena guna action yang lain through the court. Yeah? That is civil suit yang biasa lah to obtain a judgment. So bila judgment tak bayar, execute the judgment, then boleh buat winding up application through notice of demand pun boleh. Yeah? So yang tu matter of macam choice of macam proceeding to be taken by the lawyers of the creditors. Yeah? So we should avoid taking winding up application when the debt is disputed. Yeah, so on the part of the company pula, bila ada NOD against disputed debt, so the company tu boleh oppose by way of fortunate injunction. Yeah? Okay, clear ya? Yang ni ulangan lah. Ya? Boleh? Okay, so yang kat sini dah dekat winding up petition dah. Saya rasa yang ni the rest tu will be covered by Cik Azmi. Yeah? So yang kat sini, yang ni saya dah explain dah, judgment is not a prerequisite for winding up petition. Yeah? Right, so that is procedure for winding up winding up of the company will be covered by Cik Azmi. So I believe Cik Azmi will cover on the part of the petition and the affidavit sample tu dah ada dalam goals. Yeah? Okay, so by then we will finish the topic of compulsory winding up. So and finish the subject as well. Yeah? So I hope lepas mungkin dalam minggu depan tu saya will come up with the commentary for your bankruptcy proceeding as well. Eh? Boleh? Okay, ada chat apa-apa tak? Oh, tak ada. Okay, so is there any question? Saya tak apa? Okay. So berapa orang? Ada 74. So kita consistently ada 74 orang. Apa si Si Ilhan tak pergi sekolah hari ni sesama. Macam tu lah dia. Okay, so ada soalan apa-apa? Consistently kita punya attendance, saya cakap tentang attendance tadi. Consistently kita ada 74 orang kan. So I hope you can apa yang tak datang tu boleh tak explain. Saya nak minta mungkin sampaikan pada kawan-kawan macam mana saya letak notis ke, mungkin saya sampaikan kepada Syauki. Syauki ada tak pagi ni? Minta apa explain ya, sebab apa dia akan affect kita punya file jugalah bila ramai yang tak datang. Syauki ada? Boleh tak letakkan notis minta yang tak hadir kelas ataupun dia tengok video kemudiannya tu explain dekat saya, macam WhatsApp saya bagi tahu, sebab kita so far kita consistent number is about 75 to 80 macam tu. So where is the rest about 15 people?
Okay, madam.
Okay. Alright. So is there any question before we dismiss? Malam ni ada 1 jam lagi kelas dengan Cik Azmi. Ini ganti yang kelas minggu lepas lah. Ada soalan sebelum kita dismiss? Tak ada ya? Okay, so in such a case, if necessary kita ada mungkin kalau ada macam nak personal communication ke dengan saya minggu depan, sebab minggu depan last week kan. Okay, so mungkin kita tak perlu ada kelas yang mass lecture macam ni. So tapi kalau ada yang perlukan macam ada soalan ke apa-apa tentang assignment ke, you can contact me directly. Yeah? So okay, okay, Adila tanya ya, task tu in a group or a firm? In a group, tak kisahlah regardless firm tu tak apa, saya tengok in a group. So remember to put your name of the members of the group. Yeah? Okay, Adila. Okay, so in that situation, I thank you very much for your attention. I'm sorry for the mungkin dekat sekeliling ni agak bising juga. Yeah. Okay, thank you so much. Yeah. I wish you selamat hari raya lah ya. Selamat hari raya. Have a happy time, blessed time with your family. Yeah. Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Saya share nanti Zoom link dengan siapa, dengan Syauki. Yeah? Okay. Alright. Okay, thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Doktor.
You're welcome.